The process with regard to contesting a will is controlled by in Pennsylvania by the Orphans Court in Pennsylvania. That's a separate court that deals with wills and trust, guardianships, and those types of materials that involve disposition of assets by an individual after their date of death. And in this particular process, if you believe that the will has not been executed in a proper manner, you have two alternatives. The first one is you can file with the Register of Wills what they call a caveat that says, this will is not the right will. There is another will, and here's the second will, and this is the right will. And therefore, you're putting the Register of Wills on notice that they should not accept the first will, and or they should not move for administration of the estate because they have the wrong will. And that process is a process that's determined by the Register of Wills with a short hearing, and then they will make a ruling subsequent to the hearing. And they'll either accept the first will, accept the second will, or they'll make a determination of whether the will was valid at all. Was it properly executed? Was it properly witnessed? And that goes to actually the substance of the will itself. The next process is, all right, we have a will. It's been subject to probate, but you as the beneficiary believe that there is someone who has either influenced the testator, the person executing the will, unduly to change the terms of the will to benefit them, or you believe that that person who executed the will did not have sufficient capacity at the time that they executed the will to actually know what they were doing. Did they know their objects of their bounty, that is their children, their family members that would receive the benefits? Did they know what their assets were? Did they know they had a house? Did they know what was in their bank account? Those types of questions are determined. But the process itself is you have to actually file a petition with the Orphans Court in which you raise a contest of the will. And that petition process requires you to file it with the court. It outlines what the will is. It outlines the details of the circumstances that you believe led to this improper will being admitted into probate, which is accepted by the Register of Wills for processing of the estate. And you have to then come forward with sufficient evidence to prove the undue influence, either through somewhat other individual who influenced the testator, that the testator had a weakened intellect, that there was an opportunity to access them and to influence them, and or you then have the opportunity to prove that it was under undue influence, or under diminished capacity, which means you now have to prove that the testator, at the time that they executed the will, did not know the objects of their bounty, did not understand what they had, and that they were in a state in which they were not making an intelligent or knowledgeable decision. The process then begins that you can conduct discovery with the permission of the court and determine which witnesses you wish to process into the court, before the court, to prove your case of either undue influence or diminished capacity, and the court will eventually hold a hearing. And at that hearing, they will determine, based upon the evidence you presented, and I'm sure the opposition of the person who's defending the will, to say, I did prove my case of undue influence, I did prove my case of diminished capacity, and then the court will accept the previous will or the will that you wish to present to the court, and they'll disregard the will that has been subject to undue influence or diminished capacity.